Good evening, and welcome to the final round of the 96th Annual New York City Bar National Moot Court Competition. This event is co-sponsored by the Moot Court Competition Committee of the New York City Bar and the American College of Trial Lawyers. My name is Byron Huang, co-chair of the City Bar's National Moot Court Competition Committee, along with my co-chair, Daniel Rothschild. The argument you're about to see is the culmination of an immense competition that spans 5 months. In November 2018, 174 teams from 120 schools participated in 14 regional competitions across the country. Each region sent its 2 best teams to compete this week in the national final rounds at the New York City Bar Association. We began the national rounds with 28 teams, but after 4 days and 42 arguments, here we are, down to the final 2. This year's case, captioned Omar Little versus Marlowe Motors Incorporated, involves 2 distinct and important issues. First, whether a state may exercise general personal jurisdiction over a corporation based solely on that corporation's registration to do business in that state. And 2, whether the design of a fully autonomous vehicle, in light of an accident which it performed as intended, is defective by virtue of being unreasonably dangerous. Here is a hopefully brief factual summary to help you follow along. This case arises out of a car accident involving Marlowe Motors' Level 5 autonomous vehicle, the Model Herc. Marlowe Motors issued a limited release of the Model Herc on January 7, 2017, marketing it as the world's first fully autonomous vehicle. In essence, the vehicle is fully automated, capable of driving from one destination to another, completely unaided by the human in the vehicle. The only direction the passenger need give is the destination. Prior to its release, Marlowe Motors performed extensive testing of the Model Herc's underlying programming and logic network in order to protect the passenger within. As such, Marlowe Motors designed the internal code to quickly analyze the size and distance of objects so the internal system could determine the best course of action when confronted with dangerous situations. However, the software and cameras installed in the Model Herc could not discern the depth of an object or the texture of the surface of an object. Marlowe Motors determined that it would be financially prohibitive for the company to design and build sensors to determine the density and chemical makeup of obstacles on the road, and thus did not do so. Omar Little is a citizen of the state of Colvin. He is an avid follower of the progress of autonomous vehicles and necessarily an avid follower of Marlowe Motors. Omar purchased a Model Herc the moment it was released and was so excited that he went to pick it up in California, Marlowe Motors headquarters. Over the next several months, Omar drove his Model Herc on both fully autonomous mode and manual mode without incident until the night of May 26, 2017. That night, Omar attended a gala event in the state of Icaro, celebrating the progress of artificial intelligence. As the festivities wound down, Omar entered his Model Herc, set the system to fully automatic, and directed the car to take him home. Omar fell asleep soon after the car began driving. As the car drove onto a wide 4-lane interstate road, there was an LED traffic sign above that indicated a large sinkhole in the right lane a mile or so down the highway. As the Model Herc drove, the weather worsened, visibility decreased, and it began to rain. Omar's Model Herc noted the weather change, shifted from the leftmost lane to the second leftmost lane, and decreased the speed of the vehicle. Several seconds later, the Model Herc's frontline sensors detected a large object approaching quickly, approximately 7 feet by 7 feet. In that moment, the internal system detected the highway divider 1 lane over to its left, several small cone-shaped objects in the lane second from the rightmost lane, and found no cars behind it. The Model Herc's internal system determined that braking or swerving to the left would result in greater injury, and decided to swerve to the right, crashing into the sinkhole and causing severe spinal damage to Omar Little. The accident report later revealed that the object was a California king-size mattress that had fallen off the back of a truck. Omar brought suit against Marlowe Motors in the United States District Court for the Eastern District of Colvin, alleging that Marlowe Motors should be found strictly liable due to the Model Herc's unreasonably dangerous design. The District Court held that Marlowe Motors' registration to do business in the state of Colvin constituted consent to general personal jurisdiction. Further, the jury in that proceeding determined that the Model Herc was defective by virtue of being unreasonably dangerous. The 14th Circuit affirmed the trial court on the jurisdictional issue, but reversed on the issue of defective design. The parties brought this appeal to the Supreme Court. We will see argument in a few moments, but first, Daniel will introduce our teams and our judges.
Advancing to the final rounds of the 69th Annual National Moot Court Competition and representing the petitioner, Omar Little, will be Northwestern University. Representing Marlowe Motors Incorporated, the respondent will be the University of Alabama. Those judging tonight include the following. The chief judge for our argument tonight will be the judge of the Second Circuit Court of Appeals for the United States, Richard Wesley. Assisting him as Associate Justices will be the Honorable Ellen Gesmer, New York State Supreme Court Appellate Division, the Honorable Cheryl Chambers, United States Supreme Court Appellate Division, and the Honorable Salian Scarpella, New York State Supreme Court Commercial Division. Tonight they will also be joined by the President of the New York City Bar Association, Roger Maldonado, and the President of the American College of Trial Lawyers, Jeffrey Lyon. The arguments will begin in just a few minutes.
Holy mackerel. Okay, I'm going to disappear. Please be seated, everyone. Yeah, I know. I don't know if I'm afraid I'm going to disappear behind this lectern. Yeah, I am. I'm going to disappear. I'm going to move that corner. I'll sit over here. Oh, okay. We'll manage here. There we go. All right. The case of the day is Omar Little versus Marlowe Motors. Petitioners ready? And respondents ready? Proceed.
Chief Justice, Associate Justices, and may it please the Court. My name is Linda Chu, and I, along with my co-counsel, Mr. Clayton Fates, represent the petitioner in this case, Mr. Omar Little. I will argue the jurisdiction issue, and Mr. Fates will address the design defect issue. Your Honors, we would like to reserve 2 minutes for rebuttal.
Fair enough.
The Court today should affirm the 14th Circuit's jurisdiction holding for 2 reasons. First, because Daimler simply did not disrupt or affect consent to jurisdiction. And secondly, because Marlowe Motors consented to jurisdiction in Colvin by registering to do business in that state. This Court has long recognized that personal jurisdiction is an individual, waivable right, and that is exactly what Marlowe Motors did when it complied with Colvin sections 317, 318, and 3104.
But you would agree that almost every state has a statute like Section 318 in order to allow companies to do business in their states, correct?
Yes, Your Honor.
And so doesn't this really, the implication of a ruling, affirming this ruling would mean that corporations would be subject to suit essentially in every state where they do any business at all?
No, Your Honor, and that is because a majority of states, 42 states, have already decided, either through their state legislature or through their state courts, that registering to do business is not consent. In fact, 10
But
states...
wouldn't they be likely to change that position now if we were to come out this way?
Those states would be able to, Your Honor. I can't speculate as to whether they may want to or not. And again, that's because states may want to be friendly to defendants and to corporations. If every state were to adopt such a rule, they would likely be losing a lot of business and a lot of revenue for the state.
So let me ask you this. Judge Ginsburg wrote, plaintiffs approve the exercise of general jurisdiction in every state in which a corporation engages in substantial, continuous, systematic course of business. That formulation, we hold, is unacceptable, grasping. Now, when you look at the facts of this case and you apply that standard, what is your thought?
Well, Your Honor is referring to Justice Ginsburg's opinion in Daimler, and Daimler is not relevant here because Daimler is about a business's presence, about a business's systematic and continuous contacts such that it is at home in a state. That is not relevant in the case before us today because the district court already found, in the record at 2, that Marlowe Motors had no contacts in the state of Colvin. Mr. Little is not asserting general jurisdiction based on Marlowe Motors' presence or its activities within the state, rather based on its consent from registration.
Okay, so then the statute that you're citing, no foreign corporation shall do any business in this state until it is filed with the Secretary of State a statement executed by an authorized officer setting forth the name and address of its registered agent. Where does that say, and I consent to general jurisdiction by this registration?
Your Honor is correct that that provision does not explicitly say consent.
No, it does not. Even implicitly does it say it. It doesn't say it at all, right? So how can we impose that burden on a corporation based on that language? That gives it really no notice that that's what it would be doing.
Your Honor, Section 317 cannot be read in a vacuum. The following provision, Section 318, states that that registered agent may receive all service of process issued out of any Colvin court. Now, those 2 registration statutes with the long-arm statute did put Marlowe Motors and any other registered corporations on notice that it was liable to suit. That is
Except the states that have found that registration statutes like that don't result in jurisdiction have essentially identical statutes. So how would a corporation know when it agrees to that which kind of situation they would find themselves?
Your Honor is correct that states with similar language have also found the opposite result. But there are also many jurisdictions with almost identical language that do hold registering is consent. Because Marlowe Motors knew about this mechanism to jurisdiction, and because Pennsylvania Fire, this court's case in 1917 that first recognized consent as an avenue to jurisdiction, has never been overruled.
As a follow-up,
Go ahead.
Can the registration requirement be interpreted instead as providing a practical means of effecting in-state service where the exercise of personal jurisdiction is otherwise constitutionally permitted?
I'm sorry, Your Honor. Would you restate? If you're asking?
What I'm asking, can you interpret the registration requirement as instead providing a practical means of affecting in-state service where it's constitutionally permitted?
Yes, Your Honor. Of course, maintaining an agent for service of process in the state does enable plaintiffs to more readily and easily serve those defendant corporations.
I mean, because Marlowe Motors isn't everywhere, but its products are perhaps everywhere. And so therefore Marlowe Motors could expect perhaps to be subject to the jurisdiction of the state because of a tortious act that occurs outside the state but injures someone within the state. The defective design of a product that then causes an injury within the state. But Marlowe Motors is nowhere to be found. Isn't the agency understood that it makes it easier for those types of claims, the long-arm jurisdiction already having been extended to the constitutional limit?
Your Honor is correct that corporations that cause tortious injury in a state are certainly liable to suit under specific jurisdiction. I'd like to distinguish the lack of presence of Marlowe Motors in Colvin. Again, Marlowe Motors' contacts are not at issue in this case. The question certified before the court today is whether general jurisdiction is appropriate only in light of Marlowe Motors' registration, and it is. Again, because it doesn't matter that Marlowe Motors has no presence in the state of Colvin. The fact that it registered an agent and
But how is it a knowing consent? It's just a consent to the authorization for service of process. It doesn't say and to the jurisdiction of the state like the Pennsylvania statute does. It just says an authorization for service. They can expect to be sued there for tortious acts under the long-arm statute, but surely that can't mean that they're consenting to the general jurisdiction of the state, does it? That's a phenomenal leap with regard to the registration, isn't it?
No, Your Honor, and because this court has already recognized in Pennsylvania Fire and Robert Mitchell Furniture that such an affirmative act of maintaining that agent is a way to consent.
Well, should it be a knowing affirmative act?
Consent need not be knowing or voluntary.
Need not be knowing?
No, Your Honor. If Marlowe Motors were to appear in this case before the district court and involuntarily waive its rights to jurisdiction, it may do so involuntarily.
I don't know how you effect a waiver when you don't know what you're waiving. How do you do that?
Again, because it need not be an affirmative knowledge. Even if Marlowe Motors didn't purposefully choose to register and ignore the fact that it could be liable to jurisdiction, the court today can still constitutionally hold that it was on sufficient notice from the language of Colvin statutes.
Okay.
Again, 3104, while it does not say general personal jurisdiction, does include language that it should be construed to the maximum extent possible. And states that want to reach its arms out to reach defendants beyond its state borders should still have the option to do so through registration. In Robert Mitchell Furniture, decided just 4 years after Pennsylvania Fire, this court held that the purpose of such registration statutes is to secure local jurisdiction. Marlowe Motors, being a large, international, sophisticated company, cannot seriously contend that they registered in Colvin, maintained an agent for all service of process there, and are now surprised that they are being hailed into court. Mr.
But they
Little,
don't have any choice.
Yeah, go ahead.
But do they have any meaningful choice about whether or not to register if they want to do business at all in your state?
Certainly, Your Honor. And it's important to remember that in this record, Marlowe Motors was found to not have any contacts. They registered in Colvin without maintaining a dealership there, without having any employees there, or any real presence. And so the choice of registration should carry more weight than it did for Marlowe Motors.
But isn't the real question, wouldn't that, if we go with your theory, wouldn't that subvert the Supreme Court's holding in Daimler?
No, Your Honor. Daimler addressed the contacts theory to general jurisdiction. In Daimler, the word consent is used exactly once, and it is to say that the contacts analysis described in Daimler is only necessary where a defendant has not already consented. That's why this analysis, following Pennsylvania Fire and Robert Mitchell Furniture, is entirely apart and distinct from Daimler. Just because Marlowe Motors doesn't have a business presence there is irrelevant to this case. It submitted itself to Colvin courts by registering to do business and by maintaining an agent permanently there to receive service of process.
Okay, and how does that comport with international shoe?
Well, in international shoe, Your Honor, this court held that personal jurisdiction must have sufficient notice and could be
Contacts, some contacts,
yes,
right?
The
And
minimum,
you're saying there's none here.
the minimum contacts analysis is different from consent. If Marlowe Motors were to include a forum selection clause with its consumers, choosing a specific forum and waiving jurisdiction rights where it may not be at home, it can choose to do so.
Yeah, and I'll give you that. That makes some sense to me. But there's got to be a limiting principle to consent. And what would so I have to take you back to this knowing idea. The fact that they know that they could be brought into the jurisdiction under a long-arm statute that has a constitutional limitation, that's as to specific jurisdiction. That's not as to general jurisdiction. How is the consent some way, in light of knowing that the service of process that they might be called into court in the state because they've done a tortious act outside the state that has an effect within the state? How does that transmute into? How does that morph into a consent to general jurisdiction, a knowing consent to general jurisdiction?
It may not have been affirmatively knowing, Your Honor, but the language of Sections 317, 318, and 3104 read together in tandem did put Marlowe Motors on notice. The specific statutory language...
Sure, notice that if they make a bad car in Toledo and it ends up in the state and causes somebody injury, yes, and that they have an agent for service there, but not that a lawsuit involving a contract they had in Argentina where the Argentine government could be litigated in the United States, does it?
It It doesn't include that language, Your Honor. That's correct. But other jurisdictions have
But you're
held-
talking about general jurisdiction and premising on consent. And I understand your argument in the context that consent negates international shoe. People can consent to things. And my question to you is, there has to be a limiting principle to it. What is it, the limiting principle of consent? Knowing?
It does not need to be knowing, Your Honor.
Okay.
You're saying it's enough to have notice as opposed to know?
Correct, yes.
Okay.
Well, but where is the notice?
The notice comes first from the explicit plain language of those statutory provisions, as well as the fact that this court and other jurisdictions have found consent from registration to do business.
Where in the statute is there notice that they're subjecting themselves to general jurisdiction?
The long-arm statute does not say general jurisdiction, Your Honor, but it's not limited to specific jurisdiction either. In the final clause of Section 3104 says that the provision is meant to be construed to the maximum extent
Right,
possible.
so how does that convey notice?
Because Marlowe Motors, with Section 318, knowing that its agent may receive all service of process issued out of any Colvin court, and the fact that 3104 says that foreign corporations may be reached through those agents to the maximum extent possible, was notice. The fact that consent from registration has existed for over a century and still been found even after Daimler. In district courts in Iowa, Nebraska, and Pennsylvania, finding consent from registration still exists, and it certainly exists in Colvin today. Mr. Little suffered catastrophic injuries at the hands of this model HERC, and he should be able to recover in the state of Colvin. Thank you.
Okay, thank you very much.
Thank you.
Mr. Fates?
Yes, Your Honor.
Very good. Go ahead, Mr. Fates.
Mr. Chief Justice, and may it please the Court, I am Clayton Fates, and I continue on behalf of the petitioner Omar Little. And in my time before the Court, I'll address how and why the fully autonomous model HERC is a defectively designed vehicle. And that's for two reasons. The first is that a jury was already properly instructed on a viable approach to design defect cases, and that's the consumer expectations test. That traditional approach to products liability is the appropriate test to apply, particularly with regard to new products like autonomous vehicles. And second, because even if the Court today chooses to adopt the newer risk utility test, the vehicle is still defectively designed. Now, the question certified to the Court today is remarkable because it inquires as to whether or not the vehicle is defective by way of being unreasonably dangerous. That's a factual question, which this Court doesn't normally consider. But the facts of this case are important. The Court today should bear in mind that the fully autonomous model HERC was functioning as it was designed to do when it needlessly swerved into a cavernous sinkhole that was clearly marked by a brightly lit LED sign and traffic cones warning of the danger.
Well, when you say needlessly, wasn't the car in fact designed to prevent going into the wall, which was to its left, and to avoid the obstruction which its mechanism saw in front of it, and the cones which it saw as opposed to the much smaller cones to the right? So when you say needlessly, I'm a little confused where that comes from.
Well, Your Honor, in the record at page 6, the jury found that Omar Little credibly testified that he would have made a safer choice than the model HERC made, either to drive through the mattress, to brake since there were no vehicles behind him, or to tune into the empty left lane next to him. The fact here is the vehicle did not see the sinkhole. When it made the decision to swerve to the right, it was unaware of the danger that would have been obvious to a human driver. And that is one of the reasons that this design is defective.
Is it proper for this Court to take into account the number of lives that this new technology would save, notwithstanding what happened to your client?
Yes, Your Honor. There's no question that autonomous vehicles show great promise.
And if that's true, then shouldn't we be applying the risk utility test rather than the consumer-oriented test?
No, Your Honor, and that's for two reasons. The first is that the consumer expectations test is manageable for juries. It asks a single, discrete question. It asks whether a product is unreasonably dangerous because it's more dangerous than reasonable consumers.
But in judging a run-of-the-mill car, the standard of ordinary consumers' expectation, you could figure that out, but could you figure out ordinary expectations with respect to a self-driving car?
Your Honor, that's one of the reasons the consumer expectations actually should be applied in this case. And it's true that self-driving cars haven't been around as long. Consumers haven't had as much time to get used to them, the risks that they pose, the opportunities that they present. For this reason, it's important that the court today ask what consumers actually expect about these vehicles, so that when Marlowe Motors sells a product to a person like Omar Little, he's not serving as a guinea pig for this large corporation to test out how safe their product actually is. The bottom line here is that Omar Little owned this car for just a matter of months. He drove only a few thousand miles in the model Herc before it caused an accident.
Are you saying that in order to sell this car, the company has to guarantee that there will never be an accident?
Of course not, Your Honor.
So where do we draw the line?
Because no vehicle is crash-proof, the vehicle doesn't have to be perfect. But according to the record, there was an upgrade to the sensors and the decision-making software that Marlowe Motors could have integrated into the design of this vehicle, and they chose not to. They knew it could be safer than it was, and they released it anyway.
Yeah, but that's a slippery slope, because if you spend unlimited amount of money, anything could be a little bit better, but no one will buy it if you spend a little bit amount of money. And that's why it seems like the risk utility test is the right one, because who would know, what would a reasonable consumer expect with respect to whether or not to drive into a mattress or swerve to the left? Because this particular person did it. Is that what a reasonable consumer would have done or expected?
No, Your Honor, and we're not asking today that the court hold Marlowe Motors up to a standard of perfection. We're only holding them up to the standard of what a reasonable consumer would expect the vehicle to do. Now, here, because this is a new type of product, reasonable consumers would expect the vehicle to perform as Marlowe Motors claimed that it would. They told Mr. Little that this car would carry him safely without intervention from him as the driver from point A to point B.
No, but again, what you're saying is they guaranteed he would not have an accident. That's what that sounds like, but that's not what they told him, right?
Well, Your Honor, they claimed that this would have been a fully autonomous vehicle that could transport him without human interaction.
And is that true? Was that it could do that, right?
It could on some occasions, but not on this one. Omar Little did not safely reach his destination. And if a human had been alert and behind the wheel, it's possible that this accident never would have occurred. There's another important point. Your Honor nods to the risk utility test, but risk utility asks a plaintiff to establish that a reasonable alternative design exists.
Well, but that would simply require expert testimony, and we use expert testimony all the time, and juries evaluate that all the time. Why wouldn't that be appropriate for a jury to have to evaluate that in something like this that's new and complex?
Well, what's critical here is that the autonomous model Herc is the first of its kind. And what that means is that it's extraordinarily difficult for Mr. Little to establish that another alternative exists. If this were a common product, even a sophisticated product like a computer or a cell phone, there are multiple models of cell phone and computer in the marketplace that Mr. Little could compare one product to another and evaluate whether they were reasonably safer. In this case, this is the only vehicle of its kind. There is no alternative. What that means is that if we imagine a version of the model Herc that is 100% guaranteed to cause its driver a catastrophic accident within 6 months, no plaintiff would be able to recover simply because they can't establish that an alternative to its design exists. That's unreasonable.
But you just said that it was possible that the accident wouldn't have occurred. Well, isn't anything possible? Aren't we dealing with what's reasonable under these circumstances? And wasn't the choice that the vehicle made a reasonable choice given what was happening?
No, Your Honor. And that's because the circumstances that surrounded this accident arise all the time. There are obstacles in the
mattresses flying on the highway?
Perhaps not a mattress specifically, Your Honor, but deer will run out into the middle of the road. That'll be read by the autonomous model Herc sensors as an obstacle in front. Okay. If that deer runs out into the street on a mountain road with a sheer drop-off to one side, according to the facts in this case, the vehicle's going to swerve off that cliff.
Well, most times when deer run out in the road, the car hits the deer.
Yes, Your Honor. And in fact, in driver's ed, student drivers are told to drive through the deer rather than swerve to the side because that's a safer option. And the model Herc didn't know as much as a 16-year-old in a driver's ed class. It chose to swerve into a dangerous situation and plummet into a sinkhole.
But isn't the question really whether the risks inherent were how you balance the risks inherent in the design against the benefits. And we can't really determine that by talking about a random deer or a mattress on the highway. That's the stuff of experts, which would be invoked by instructions involving risk utility the risk utility test. So I'm still troubled by why the consumer preference test, the consumer expectation test, makes more sense than a test that would involve expert testimony and reasoned weighing of benefits and costs.
Well, again, Your Honor, that's partly because of the difficulty, the extraordinarily high bar of proving an alternative design exists here that would bar plaintiffs from recovering in any such case. But it's crucial to understand that the consumer expectations test and the risk utility test aren't really that distinct. Even in jurisdictions that still nominally maintain the consumer expectations test or jurisdictions that have adopted risk utility, in effect, they're both factors-based, fact-intensive tests, and they share many of the same factors. In consumer expectations jurisdictions, evidence of an alternative design is still powerful. Under risk utility, consumer expectations is an important factor that juries will consider and be instructed on. Here, a jury's already heard the facts of this case. They heard testimony from every witness that Marlowe Motors chose to put on. They heard Mr. Little's side of the story, and they found in his favor. And for that reason, we should respect that jury's verdict because the two tests aren't so distinct. They both get at the same question. It's whether or not a product is unreasonably dangerous. And again, critically, Mr. Little did not own this vehicle for very long. This is a limited early release of the Model Herc.
Should we decide whether a vehicle is unreasonably dangerous based on one accident?
No, Your Honor. But we can look at the many ways in which this car failed and determine that its design is defective. As it drove down the highway, it failed to recognize a brightly lit LED sign warning of danger down the road. A car horn sounded in front of it. It didn't know what that sound meant. It didn't know that orange traffic cones typically demark danger. It looked at those and saw an object that would be safe to drive over. It failed in a number of ways that a reasonably designed autonomous vehicle, or certainly a human driver, would have succeeded in ensuring that this driver, Omar Little, remains safe.
But wasn't Mr. Little a very sophisticated consumer of this type of vehicle? Didn't he? I mean, wasn't this his dream car that he was waiting for?
That's correct, Your Honor. And in our opinion, that makes it all the more tragic that it had the result that it did. However, under either tests, when we look at consumer expectations, it's not about Omar Little's subjective expectations. Even if he had the highest of hopes for this new technology, that's not the inquiry. It's an objective question about what ordinary consumers reasonably expect of the product. And they expect this vehicle not to crash in the way that it did. Now, this is just one incident. And it's also critical that finding this design defective only holds Marlowe Motors accountable for the damages that the defects in this design actually cause. If this is truly a fluke, if this is really such an unusual circumstance that this vehicle is going to be safe, a statistical likelihood of the time, they're off the hook. They won't have to pay damages to very many plaintiffs like Mr. Little. On the other hand, if the court finds in Marlowe Motors' favor today that the vehicle is not defectively designed, anyone else similarly harmed when the autonomous driving system causes an accident that it simply didn't have to, a needless accident, those plaintiffs are going to be barred from recovery. And that's one of the reasons it's important that the court find this vehicle is defectively designed under either test.
Well, I mean, that's for a jury to find, correct?
Yes,
and
Your
if
Honor.
you get the wrong jury instruction, then it has to go back, doesn't it?
We would be happy with that result, Your Honor, but again, it's important to know, unusual though it is, a factual question has been certified to the court today. And so it's a question that the court can choose to answer, that as a matter of fact, under either tests with the facts presented before it, this vehicle was defectively designed.
So if we found that the utility of adding in the sensors that would make the car prohibitively expensive and essentially doom it from being purchased didn't outweigh the risk, then we would affirm the 14th Circuit, correct?
Yes, I believe so.
All right. But your position is that it didn't, under the risk utility test, that the company should have spent that money, even if it would have made the car essentially unbuyable?
Well, Your Honor, again, under either test, there's an interaction between a sophisticated company, who is effectively the least cost avoider for this kind of tortious harm, who knows a lot about how their product functions, and a consumer who is trying to make an informed choice about the risks he assumes when he gets behind the wheel of a car. The fact that they made exorbitant claims about the safety of this vehicle is simply an abuse of the power that Marlowe Motors has. Omar Little made an informed choice to buy a vehicle that he believed would carry him safely from A to B, and it failed to live up to that expectation. Based on the claims that Marlowe Motors has made, not only in advertising with puffery and everything that goes along with that, but also in interviews where they're presenting cold facts about the technology they've implemented in this vehicle, they've claimed that this car is going to be safer than a human-driven car.
When I listen to what you're saying, it seems a lot like what was asked before, that you're saying they guaranteed this car would never have an accident.
No, Your Honor. We can imagine a circumstance in which an accident wouldn't be avoidable, even for a sophisticated self-driving car. We would imagine an accident where another driver's negligence caused this vehicle to have a collision. There's a number of circumstances in which we wouldn't find this car to be defectively designed. But here, again, because of the many ways in which this car failed to recognize the danger presented by the sinkhole and made an affirmative choice to swerve to the right and drive where the road effectively ended and plummet the car into this sinkhole, that's a design defect.
I want to ask you about remedy again here, what you want from us. The Fourth Circuit remanded for the jury to reconsider on appropriate instruction, right?
Your Honor, the record actually is conflicted on this point. In the opinion, the court reverses the jury's decision, but procedurally we believe...
Well, it vacates the jury's decision. Of course it does, because it remands for a new trial because of the improper instruction, correct?
Again, Your Honor, the opinion actually says reverses, and that's...
Well, of course it has to reverse.
Very good.
I mean, otherwise you don't affirm a jury's verdict and then say the instruction was improper. I mean, the remedy is reversal, but it's in essence a vacature of the jury verdict, and then a new trial. It ordered a new trial on the appropriate instruction, with the appropriate instruction, right?
Yes, Your Honor.
And so what do you want us to do today? Tell me what you want, not what other options are, but tell me what you want us to do and why.
Your Honor, my time has expired. I'd like to...
I'll let you answer the question. That's why I'm in the center. Go ahead.
Mr. Chief Justice, we would like the court today to reinstate the jury's verdict and find Marlowe Motors accountable for the damage their defective vehicle caused.
And lastly, the reason is?
The reason is that the jury was properly instructed under the consumer expectations test, and therefore its verdict should be respected.
Very good. Thank you very much.
Thank you.
All right. We'll hear from the respondents. There you go, Ms. Colson.
Thank you, Chief Justice, and may it please the court. Petitioner requests that this court reduce questions of personal jurisdiction and design defect to a one-size-fits-all test.
Ms. Colson, I beg your indulgence. I'm a little hard of hearing. That's what happens when you become a federal judge. So indulge me and yell at me, please.
Absolutely, Your Honor. I apologize. My
I know
voice
you.
is weak
Well,
today.
because you won so many times, you had to do these many arguments. Go ahead. Go ahead.
But to do so, to reduce these questions to a one-size-fits-all test, would be to ignore the sophistication of both issues and the facts of this case. My name is Ann Miles Golson, and I, along with my co-counsel, Corey Church, represent Marlowe Motors, the respondent in this case. Due process is the cornerstone of any personal jurisdiction analysis. The question in this case is whether this court should abandon due process based solely on a grasping interpretation of vague registration statutes. The 14th Circuit erroneously found that the district court had personal jurisdiction over Marlowe Motors based solely on these vague statutes.
What if there were state court decisions that had interpreted the statute to that, for example, like New York has done, interpreted a general statute of registration that it was a consent to general jurisdiction? What would your answer be then?
Your Honor, while that state Supreme Court interpretation would, under the Pennsylvania Fire line of cases, confer general personal jurisdiction, it would not be in line with the reasoning of this court in International Shoe and its progeny, and most recently in Daimler AG v. Baumann.
Are corporations capable of willful acts?
Absolutely, Your Honor.
Corporations can consent to things. They sign contracts all the time, don't they?
Absolutely, Your Honor.
Then why can't a corporation agree to do when it does business in a particular state to subject itself to the general jurisdiction of that state? What's wrong or immoral or unconstitutional about that?
Your Honor, while there is nothing immoral with that, it is against this court's due process jurisprudence, which has clearly limited the exercise of general personal jurisdiction.
Well, now, when I buy a product, sometimes I consent to the jurisdiction of Delaware, or I consent to the that little thing that comes up on my iPad and says agree.
Yes, Your Honor.
I also agree to arbitrate it now. I find out, and I have views of that too. But in any event, I agree to the jurisdiction of something. That's okay, isn't it?
Absolutely, Your
Well,
Honor.
I live in Livonia, New York. I'm a million miles away from Delaware. I've never been to Delaware. I have no desire to be in Delaware. Then how can I consent to it, but General Motors can't?
Your Honor, because that exercise is consent to specific personal jurisdiction. By checking that box, you're consenting to personal jurisdiction that arises under that
General
contract.
Motors is organized in Delaware. Are they not personally present in Delaware?
Your Honor, absolutely.
Okay, then General Motors is a person, correct?
Yes, Your Honor, according to this court's jurisprudence.
So then General Motors can agree to personally be present somewhere by consenting to it, can't they?
Absolutely, Your Honor. And these corporate registration statutes do exactly that. Going back to this court's decision in Morrison Company v. Scandinavia Insurance Company, this court discussed the history of these corporate registration statutes, and they were enacted to provide that exact presence because of these Pennoyer-era fictions that a corporation must be physically present in a state for that state to hail that corporation into court for any transaction arising within the state. However, those fictions no longer exist. In this court's landmark case of International Shoe, this court replaced those Pennoyer-era fictions.
So that creates a curious anomaly. Corporations have better protections under the Due Process Clause than I do.
Absolutely not, Your Honor.
Not?
Well,
I can consent to jurisdiction in Alaska.
yes,
But
Your Honor.
apparently General Motors can't.
General Motors absolutely can for specific personal jurisdiction, Your Honor.
But I can consent to general jurisdiction. Why can't General Motors do the same thing? Why is General Motors so much more special than me?
Your Honor, respectfully, this court has never addressed consent by a person or by a corporation to general personal jurisdiction in its modern due process jurisprudence.
What about Pennsylvania Fire?
Pennsylvania Fire was a Pennoyer-era case. And in that case, this court did
We haven't
hold-
reversed it, have we?
Not explicitly,
Justice
Your
Holmes
Honor.
wrote that.
Yes, Your
Holmes
Honor.
is next to God.
Yes, Your Honor, I would agree. However, Pennsylvania Fire did limit, and if this court were determined that Pennsylvania Fire was not implicitly overturned by Schaefer v. Heitner or by the International Shoe and its progeny, this court would be bound to what Pennsylvania Fire stated, which is that these statutes must either explicitly state that the corporation is consenting to personal jurisdiction, or a state Supreme Court must have interpreted the statute as stating as much.
Okay, and all right, so your limiting principle is knowing.
Absolutely, Your Honor.
Okay.
And however, Marlowe Motors would contend that this court has overturned that line of cases in International Shoe v. Washington and its progeny and in Schaefer v. Heitner. However, if this court were to determine that those Pennoyer-era cases still should be relied upon for consent by registration, they must be limited to the facts of those cases and the holding of those cases. Marlowe Motors consented to register an agent for service of process in accordance with Colvin law. These statutes, present in the record at Romanet 5 and 6, merely required that corporations register an agent for service of process in the state to do business in that state. They do not speak to either personal jurisdiction or to consent.
Well, except that given the state of the law prior to Daimler, or some would say Daimler, how could a corporation not have noticed that once it decides I'm going to register because I want money from that state, I want to sell my product in that state, how could it not be on notice? Isn't it on notice that it is consenting to general jurisdiction, particularly given the state of the law?
Respectfully, Your Honor, no. These corporations are on notice that they may be held into court for specific personal jurisdiction, but not for general personal jurisdiction. This court very explicitly stated in Daimler that the exercise of general personal jurisdiction is limited to those exceptional forums where a corporation is at home or essentially at home.
But you'll agree that Daimler, if nothing else, it confirms that consent is a basis for jurisdiction. You'll agree to that?
Absolutely, Your Honor.
Okay, so, and one of the idea behind at least the policy that it seemed that Justice Ginsburg spoke about suggested that a corporation would not be able to predict where it could be sued. By registering, that gives you a good heads up that there was a possibility, especially if you're also determining who your agent is going to be for service of process, that in and of itself suggests that you could be sued.
Your Honor, it does suggest that Marlowe Motors could be sued for transactions occurring within the state. And in fact, the text of the long-arm statute, Section 3104, located in the record at Romanet 6, specifically puts Marlowe Motors on notice that it will be subject to liability for cases arising out of transactions within the state because it is not at home within the state. In many respects, that long-arm statute reflects this court's modern due process jurisprudence by subjecting at-home corporations to general personal jurisdiction and foreign corporations to specific personal jurisdiction.
But isn't it true that Daimler does not provide that in order to have consent, there must be minimal contacts with the state?
Your Honor, Daimler does not speak to the requirements for consent. It merely does mention that Perkins was the textbook case of personal jurisdiction where a company had not consented to that jurisdiction. However, this court has made very clear in its reasoning, beginning in International Shoe and culminating in Daimler, that while specific personal jurisdiction is where most cases will be litigated, that general personal jurisdiction must be limited, according to this court's wording in Goodyear Dunlop Tires Operations v. Brown, because of its sprawling nature to these specific forums where a corporation is at home or essentially at home. In Goodyear, this court explained that a corporation must be able to determine its primary conduct according to where it will be subject to such a wide-sweeping exercise of personal jurisdiction. And this reasoning is why in Daimler this court reaffirmed that only where a corporation is at home or essentially at home is where it should be subject to that general personal jurisdiction.
But given the decisions in the Third Circuit and the Eighth Circuit, certainly Marlowe Motors, which is a sophisticated corporation, would have been on notice that by registering in the state that it was subject to the possibility that it was agreeing to general jurisdiction. So why shouldn't it be held to have done whatever its research was and to decide what the risks were and be subject to that?
Your Honor, I'd like to address those two cases you referenced. In the Third Circuit in Bain v. Netlink, that case included a corporation that had registered under a 1984 statute that did explicitly state that it required consent to general personal jurisdiction. In the Eighth Circuit case, a previous state Supreme Court had interpreted the statute as conferring consent to general personal jurisdiction. Neither of those situations are present in this case. There was no state Supreme Court case that interpreted these statutes as conferring consent to general personal jurisdiction. And there is no language in this statute or in any previous statute that confers such consent to general personal jurisdiction. Rather, Marlowe Motors was put on notice by the long-arm statute that it may be subject to specific personal jurisdiction, and by this court's jurisprudence that it would not be subject to general personal jurisdiction in Colvin, but only where it is at home, in the state where it's incorporated, Delaware, where it has its principal place of business. Its headquarters is in California, and Marlowe Motors has never ceased conducting business in California, unlike the only case where this court has found a principal place of business where a company was not headquartered, which was Perkins. In that case, this court determined that general personal jurisdiction was appropriate in Ohio merely because that corporation had to cease conducting all corporate activity in the Philippines during World War II. Because of that, and because the president had moved to Ohio and conducted all activities there during the war, this court determined it was fair.
Perkins is kind of an oddball case.
Absolutely, Your
They
Honor.
were literally evicted from their home base, and so they had to be someplace.
Absolutely, Your Honor. And none of those situations have occurred here. Marlowe Motors has never ceased conducting business in California. And as indicated by the district court and on page 2 of the record, Marlowe Motors conducts no corporate activities in the state of Colvin. This court has consistently held that service of process and personal jurisdiction are two distinct concepts. Therefore, a statute requiring that a corporation register an agent for service of process does not put that corporation on notice that it will be subject to general personal jurisdiction. In Worldwide Volkswagen v. Woodson, this court held that service of process is not sufficient to obtain personal jurisdiction. These are two distinct concepts. Therefore, Marlowe Motors was absolutely on notice that it must register an agent for service of process to do business in this state.
So let me just ask you, if you're saying if the state legislature amended the statute to say, and by registering you consent to general jurisdiction, that would comport with Daimler?
No, Your Honor, that would not comport with Daimler.
So it doesn't really matter in your view?
Your Honor, no. While consent by registration does not survive this court's modern due process jurisprudence, if this court were to determine that it does, which it's entirely within this court's purview to make that decision, then this case, there still is not personal jurisdiction in this case because there's no explicit language and there's no state Supreme Court interpretation. While Marlowe Motors did conform with Colvin's law by registering an agent for service of process, it did no other business in the state of Colvin.
Is that entirely accurate? Your client solicited funds from the petitioner in Colvin, isn't that correct?
Your Honor, the record does indicate that Marlowe Motors solicited funds generally, but does not speak to whether it was a targeted solicitation to
and the petitioner accepted your client's offer in Colvin.
Your Honor, again, it doesn't speak to where that was accepted, but it does speak to Marlowe Motors accepting those funds.
So why aren't those facts sufficient to confer specific jurisdiction to the Eastern District of Colvin within the meaning of international shoes?
Your Honor, because that specific personal jurisdiction analysis is centered around the nexus between the contacts and the forum. And here the related contact, the model HERC, was at issue in the state of Icaro where the accident occurred. There is specific personal jurisdiction in the state of Icaro, but there is no specific personal jurisdiction in the state of Colvin. This court should reverse the 14th Circuit's mistaken finding of personal jurisdiction and continue its reasoning that it has made very clear in Daimler that general personal jurisdiction is limited to those exceptional forums where a corporation is at home or essentially at home. Thank you.
The long-arm statute of Colvin doesn't do him any good.
No, Your Honor.
Very good. Thank you.
Thank you.
Thank you, Mr. Chief Justice, and may it please the court. My name is Corey Church. This case demonstrates the need for uniform, comprehensive standards for determining design defects in autonomous vehicles. These standards must both protect consumers and encourage manufacturers to create innovative, life-saving technology. This court should affirm the 14th Circuit's application of the risk utility test because the risk utility test appropriately accommodates the complexity and novelty of autonomous technology.
But shouldn't jurors have to use a test that corresponds to consumers' reasonable expectations? Mr. Little was given a very explicit set of expectations by the salesperson of your client, and why shouldn't that be the standard by which this car is judged?
Well, Your Honor, it is true that consumer expectations are absolutely valuable, but consumer expectations are inappropriate as the exclusive barometer for determining design defects here. Consumer expectations can be accommodated as one factor within a more comprehensive risk utility framework, and certainly the representations of a manufacturer, like Marlowe Motors here, would be relevant in determining those consumer expectations, but again, within a more fuller and a more comprehensive picture. Ultimately, the consumer expectations test is not appropriate with products which are highly technical or complex. The Tennessee Supreme Court recognized this in Ray v. Bic Corporation when it reasoned that ordinary consumers would have a basis for expectations about coffee pots or can openers, but not about fuel injection engines.
Well, what about when the company gives you the expectation? Isn't that what the company did? They said, here's what you can expect. So why isn't that the expectation?
Well, Your Honor, it is true that in their executive interviews and in Ms. Kima Gregg's representations to Mr. Little, Marlowe Motors did make certain affirmative representations about the model HERC. It represented that the vehicle was safer than non-autonomous vehicles and even than fully autonomous vehicles with a human operator. But again, as your honors noted before, nowhere did the company represent the vehicle as entirely accident-proof or perfect. And thus, while those representations are valuable and should be considered in light of Mr. Little's situation, they should be considered, again, only as balanced against a variety of other factors.
Well, but it told Mr. Little it would do the driving. It didn't tell him to be careful because it couldn't recognize certain risks, did it?
I'm sorry, Your Honor, could you repeat your question?
Mr. Little that it wouldn't recognize certain types of risks, did it?
Your Honor, the company made no representations about the type of risk that the car would recognize. However, it is important to note here that the accident at issue occurred at night in inclement weather with a variety of obstacles on the roadway. And
a lot of people are on the road at night. I mean, is that such an unusual occurrence?
Absolutely.
Not where I live.
Excuse me, Your Honor. Absolutely not. However, there's no indication that a reasonable human driver faced with the same set of scenarios or situations, rather, that the model HERC was faced with, would not have, in that split-second decision, also have chosen to veer to the right instead of driving directly into the object in front of it or swerving to the left at risk of...
But isn't that a call for the jury, and the jury made that determination?
Well, Your Honor, it is true that at the trial level, the jury did return a verdict that the car, or the vehicle, was defectively designed, but that jury was perhaps ill-informed or unreasonable because they received inappropriate jury instructions. And thus, had the jury received a more comprehensive picture and received testimony on the variety of factors that a risk-utility analysis necessitates, the jury would have returned a different verdict, and that verdict that indeed the model HERC is not...
To follow up on what the Chief Judge asked you, if the vehicle cannot meet ordinary consumer expectations, should there then be a duty to warn about foreseeable or unavoidable risks?
Well, Your Honor, I'll answer your questions in two parts, if I may. Respectfully, this is a design defect case and not a failure to warn case. Those are two distinct causes of action within the realm of products liability law. However, second, it's the all-too unfortunate price of admission that when an ordinary consumer enters an automobile, autonomous or not, that they accept and may even expect that they may be engaged in a collision. Nowhere do manufacturers, to my knowledge, represent that regular automobiles are perfect, and Marlowe Motors certainly did not do that here. Ultimately, the consumer expectations test should be reserved for products like coffee pots with which ordinary consumers are generally familiar on an everyday basis.
Well, but isn't the whole consumers are generally familiar with cars?
It is
and
true.
It seems to me that given the design expectations, that Mr. Little had every right to assume that he could drive the car, that he could be driven in the car safely at night, and that the design was appropriate for driving at night, even in situations where there are LED warnings. Why isn't that an appropriate jury instruction given these circumstances? Why isn't it more like a coffee pot?
Well, Your Honor, respectfully, because the majority of jurisdictions refuse to apply the consumer expectations test to cases involving regular non-autonomous automobiles. In fact, the United States District Court for the District of Puerto Rico found in Fremont v. Ford Motor Company that ordinary consumers were ill-equipped to decide what minimum safety to expect from seatbelts in car accidents. Similarly, the California Court of Appeals has refused to apply the consumer expectations test to cases involving the deployment of an airbag. Autonomous vehicles are undeniably more sophisticated than their non-autonomous counterparts. Development of the model HERC, for example, involved the integration of advanced cameras, specialized sensors, and cutting-edge software. And thus, as courts have found that ordinary consumers lack consistent experience or a basis to form expectations about regular automobiles, it should be even more obvious that this court should refuse to apply the consumer expectations test.
I find it somewhat ironic. I don't know if you're familiar with a case called Coddling versus Paglia, written by Judge Jones, Hugh Jones, back in 1974. But that's when New York entered the field of strict products liability, and it is a consumer expectation test. And the premise is that people don't understand how sophisticated devices work, and so we should expect that they should work the way we expect them to work, or that we've been told how they're going to work. Mr. Little was told his car would drive itself. Apparently, it didn't. I mean, I don't know, the problem is that courts have had difficulty with regard to the use of that consumer expectation, and we slip over into design defect all the time because we're looking for a reason why.
course, Your Honor. And
why isn't it when you've got, I would think it's just the opposite of what you're arguing, is that when you've got a product that's so new and it's put out there and people have said, look at this widget is fabulous. This widget will do this, it'll do that. You take the widget and use it. That's exactly what Mr. Little did, to his dismay. I mean, he's given the expectation this car will drive itself. The very first time I ever drove my Volvo station wagon with its cruise control that keeps me 3 car lengths behind the one in front, it drove me crazy because I didn't trust it. But I learned to trust it, okay? And that's just what happened to Mr. Little. I had an expectation the car will stay 3 car lengths back. Mr. Little had the same expectation. Why isn't it the more sophisticated a device is that the consumer expectation test is more likely or a better use, a better way to measure liability?
Well, Your Honor, I'll answer your question in 2 parts, if I may. And
sure.
First, by honing in on the word strict liability that you mentioned before, and as Petitioner may have suggested when he referenced transit.
Well, that shows you when I got my law school degree, okay? But that's the way it was couched at that time.
Yes.
If the product doesn't do what it's supposed to be, you're liable. You don't have to prove negligence.
You're absolutely,
that is consumer expectation.
You're absolutely right, Your Honor, that manufacturers are held strictly liable for placing defectively designed products on the market. But what Petitioner perhaps fails to recognize is a long-standing reality of products liability law that within the realm of products law, design defect claims as opposed to manufacturing defects have always occupied a bit of a murkier territory, towing that line between pure strict liability and negligence principles. Now, second, Your Honor, to your question about why the consumer expectations test would not be appropriate here given a sophisticated product, from a policy standpoint, the risk utility test and not the consumer expectations test will actually better encourage manufacturers like Marlowe Motors to innovate and improve their vehicles with high safety standards.
Actually, I was thinking the exact opposite, that it would allow a manufacturer to say, too expensive to put in something that would the sensors that would have prevented this accident. Therefore, I have no obligation to do it. And wouldn't most corporations be looking to do less rather than more? And doesn't the risk utility test encourage that rather than discourage that?
Well, respectfully, Your Honor, no, it does not. It does necessitate on the part of the manufacturer a preemptive cost-benefit analysis, but that cost-benefit analysis does not result in a zero-sum game in which plaintiffs are unilaterally harmed at the expense of a manufacturer's bottom line. Under the risk utility test, plaintiffs have the opportunity to present a prima facie case of defective design. If plaintiffs make that showing, the burden then shifts to the manufacturer to have to disprove that design. And thus, under the risk utility test, manufacturers aware of the potential for costly design defect verdicts and equally aware that they may shoulder that heavy burden of disproving defective design claims will engage in this cost-benefit analysis, and it ensures that in the aggregate, safer products end up on the market. But as fairness...
I'm sorry, I don't follow why that would make safer products end up on the market. It seems to me that it would mean that products would end up on the market where the balance of safety against cost was what the corporation considered reasonable. Why does that result in safer products?
Well, Your Honor, perhaps one of the beauties of the risk utility test is that it enables fact finders, such as this court in the unique role that it is sitting, to look beyond the accident at issue and look to the global benefit of this technology. Manufacturers, under the risk utility test, aware of the potential for these costly design defect verdicts if they're unable to disprove defective design claims, and perhaps they will be unable to disprove those defective design claims if the plaintiff shows, among a variety of other options, that an alternative design exists. Ultimately, the risk utility test is actually the more fair test to consumers in at least 2 respects. It ensures, again, in the aggregate that safer products end up on the market, but Petitioner would have the court believe that the risk utility test places a higher burden on the plaintiff, and that's simply not true. The risk utility test actually addresses one of the key deficiencies of the consumer expectations test. That deficiency is that consumers often struggle to prove objective expectations. Now, the risk utility test, through its instruction...
Especially if a corporation tells them that the product is safe.
Well, Your Honor, yes. Obviously, manufacturers' representations
and they don't realize that cost is a factor in making the determination that whether or not they're going to incorporate some kind of safety device.
Well, Your Honor, I'll speak to your question in two parts, if I may. Again, through its instruction that juries consider a variety of factors, coupled with expert testimony on both sides of the V, the risk utility test actually affords plaintiffs more tools and more opportunities to prove their defective design claim. Now, turning to the issue that you raised perhaps of an alternative design and turning specifically to this case, this court should find that the model HURC is not defectively designed under the risk utility test, and that risk utility test would consider a variety of factors. One of those factors would be the presence, if any, of an alternative design.
Let me go back to the question that the Chief Judge raised with your adversary. What is the remedy you're asking us for? Are you asking us to make a finding or to remand?
Well, Your Honor, as the certified question is presented to the court, we would ask this court to find that the model HURC is not defectively designed. Should this court, within its purview, decide that that is, as it traditionally is, an issue for a fact finder, it should remand the court to the district level under the appropriate jury instructions, which would be the risk utility test.
Well, let me just ask you this. In balancing, couldn't one prove consumer expectations without expert testimony? And doesn't one absolutely have to have expert testimony in the risk utility version of design defect?
Well, Your Honor, it is true that in the majority of jurisdictions that employ a consumer expectations test, not as petitioner would have you believe, but expert testimony is generally precluded entirely, as you note, from that analysis.
So how is it less expensive to a plaintiff to have to do or more, or I should say beneficial to the plaintiff to have to hire an expert with the risk utility analysis as opposed to a consumer expectation analysis?
Well, Your Honor, perhaps not less expensive, but at least more fair.
I think much more expensive.
In that it would provide that plaintiff with more tools and more opportunities to prove their defective design claim. Now, there would be some circumstances under a risk utility test in which consumer expectations could weigh very heavily in favor of the plaintiff. The California Supreme Court recognized this in its Soul v. General Motors decision when it referenced the fact that ordinary consumers can have expectations about certain aspects of automobiles. Ordinary consumers expect that automobiles won't roll over and catch on fire in 2-mile-per-hour collisions. Ordinary consumers expect that automobiles won't explode while leaving the dealership. And thus, if an erroneous, or rather, if such an extraordinary circumstance like that were to arise, a risk utility test would still provide plaintiffs with minimal burden to prove that defective design claim. But ultimately, the risk utility test, again, allows this court to look beyond this one instance and allows it to look at the utility of the product to society more generally. As Marlowe Motors' extensive testing indicates, the vehicle is indeed safer. I see that my time has expired. May I briefly conclude?
Very
Chief
briefly.
Justice? And not only is the car safer than all other vehicles on the market, but it would bring with it a host of other benefits, including environmental benefits and the ability to afford elderly or physically disabled individuals a greater degree of self-sufficiency. Ultimately, then, this court should find, under the risk utility test, the model HURC is not defectively designed. Thank you.
Thank you very much. Rebuttal? Mr. Fates?
May it please the court, I have two brief points on rebuttal. Regarding the jurisdiction issue, this court does not overturn precedent by implication or innuendo. Pennsylvania Fire is still good law, which means that consent to jurisdiction by registering to do business in a state is still constitutional. It's true that Colvin's statute is not as explicit as that of Pennsylvania, which specifically identifies general jurisdiction, but Iowa, Nebraska, and Delaware have all interpreted similarly worded statutes to convey consent to general jurisdiction. Daimler stated specifically, mentioning consent only once, that the context analysis is only necessary where a defendant has not already consented. The fact is that Marlowe Motors here was on notice. Regarding the design defect claim, the respondents claim that the risk utility test favors plaintiffs or is fairer to plaintiffs simply isn't true in this case.
I'm sorry, how was it on notice? You
Because
just said it what?
Again, Your Honor, 3 states with similarly worded statutes have interpreted their own statutes to confer general jurisdiction. And so there's certainly the possibility that this language is clear enough. So Marlowe Motors should have known that it could have. Thank you. The burden of establishing a reasonable alternative design to a cutting-edge product like the Model Herc is so high that it's an absolute bar to plaintiffs bringing design defect suits for products like this. The respondent correctly said that consumers reasonably expect a vehicle not to roll and catch fire. They reasonably expect a car not to explode as it leaves the dealership. Similarly, consumers reasonably expect a self-driving car not to swerve into a sinkhole. Thank you.
Very good. I need some direction. We're going to go back down and we'll do our scoring, and then we'll be back up and announce the results. And as I understand it, do a little chat with the contestants. Is that correct? We stand in recess. I have to do that myself. Please be seated, everybody. Yeah, I use that pillow. Yeah.
Good idea.
Well, the task falls to me to deliver a few words. I do the short straw. For the members of the panel, I'd like the contestants to know that today I sat down in Foley Square and heard arguments ranging from a major cigarette case to the sentencing of two fellows who were charged with selling computer software to Russian military agencies. And so one would expect when you're at Foley Square that you would hear advocacy at its highest. I have to say that the four of you today were the equals, if not superior, to the arguments that I heard this morning, and I mean that sincerely. The thing that always strikes me when I do these moot court competitions is how terrific you are. And I teach a class at Cornell Law School on federal appellate practice, and the students argue off of the Supreme Court calendar, and it always really excites me to see young law students get up and really display an acuity to the craft, the profession to which they aspire. And your performance here today, the four of you, argues well that your careers will be successful. Unfortunately, in these matters, we draw distinctions, and we'll draw that distinction in a few minutes. But let me just make a few general comments overall. The command that you displayed with regard to the law, and I think you could tell I was a little bit more interested in the jurisdictional side. The feds now, we're thinking jurisdiction all the time. And the two of you that had the jurisdictional argument, and I think the petitioners have the really harder side of this argument in some ways. And so, that's the problem with moot court. There's a hard side and there's an easy side. That's the way it always works out. But by the way, that's the way it is in life. I had a law professor, Gray Thorne, who once said, if you don't have the law on the side and you don't have the facts on your side, you're left with trickery and deceit. And that's not always the craft of a good lawyer, but occasionally it might be. But I do think that there's the difficult side for the argument to be made, and who knows where this consent jurisdiction issue will go into the future, and Daimler presents some challenges, but I do think that at least the easier side, at least from the way things are going right now. I tend to agree with the way Judge Carney wrote Brown versus the decision in the Second Circuit this past September. On the merits side, or on the substantive side, you guys really had at it, and and stunningly so too, I think. But it's kind of this nebulous area of products liability. That's the thing that used to beguile me when I was on the New York Court of Appeals. And we had a number of products cases, and we had one called Black & Decker with regard to modifications, and then another called Liriano, which was a duty to warn case. We find those to be, they're squishy and they're hard to fit. But I thought both of you. It was interesting to me that both of you kind of said, well, you've got to argue. You've got to argue. It doesn't really matter. We win under both. That's the way you got to go with it, because you might be headed back anyhow. As long as you survive the jurisdictional problem, you might be back with both. on your side, you caught a lot of flack on your risk utility thing, but you had some good arguments about why it's not such a tough burden. Stylistically, I have absolutely nothing to say to you. If I were going to guess, you folks are from the South, and now I'm going to tell you why. And this is a northeastern prejudice, and so this is not a criticism, but I want you to hear it so that you'll know if you're ever arguing in New York, be careful. Southerners say respectfully and mean it. Northeasterners say respectfully and mean disrespectfully. And so you've got 3 New York judges here, or 4 New York judges here, and we all heard, nah, forget it, I judge you're full of. And when we hear, with all due respect, we really hear, you're really full of crap, Judge. And so I think it works very, very well south of the Mason-Dixon line, and I think it's entirely appropriate. But if you ever come up here, be careful. And that, again, that's not a criticism. I don't, it was funny. I thought to myself, they got to be from the South. They got to be from the South. So, because folks from New York would immediately think that and employ it regularly. One final thing before we announce all the awards. One of the reasons why I like to do this is it renews my faith in the rule of law. It renews my faith in the dedication that young people bring to a profession which has been extraordinarily kind to me and to the people on this dais and has been exceptionally rewarding. The law will give you the opportunity to stand up in court and to take on someone else's burden, to represent their interests, whether they be a multinational corporation or a homeless individual. The law gives you the power to bring the law to bear and the rule of law to bear on the troubles of those that seek your guidance and your counsel. It is an awesome responsibility, but it will reward you mightily. You will feel the joy and the comfort of the thanks of your clients for the work that you do for them long into the future. And it may lead you to a time on the bench. It may lead you into bar activities and other matters, but it will reward you greatly if you put the time and the effort into it. And I wish all 4 of you nothing but the very, very best. Congratulations to all 4 of you. Daniel, go ahead, get him.
All right, we'll continue with the award ceremony. Can everybody hear me? Very good. Let's just have a quick round of applause for our contestants one more time. Let's show our appreciation for our judges. Thank you so much for your... May I ask the president of the American College to come down to help us present some of the awards? Thanks.
Finally, I noticed I could have lowered this.
Oh.
Okay, we're going to start with the brief awards. The Edwin L. Weissel Jr. Award for Runner-Up Best Brief Award goes to the University of Iowa. The Harrison Tweed Award for the Best Brief goes to the University of Montana.
Holy moly.
And now for the individual awards. These are awards given to oralists in this debate. The first award is presented to the runner-up individual speaker. This prize goes to Clayton Fates of Northwestern University. You can come on. The award for Best Individual Speaker goes to Ann Miles Golson of the University of Alabama.
So the bench would like to know the University of where?
Alabama.
You were correct.
Wow. Roll Tide. Oh, my God.
And go Cats!
Wait till Valerie Caproni finds out about that. She's a graduate of the University of Alabama.
Okay, Mr. Chief Judge, would you announce the verdict of the court?
Yes, I have in this envelope kept on Funkin' Wagnall's porch. Here we go. And the winner of the round is the respondent.
We'd like to present the awards. We're going to start with the runner-up. The best team, runner-up best team, overall team is Northwestern University. Linda Q, Clayton Pates.
Pretty happy with that, isn't she? Good. Good for her.
And as we know, the Davis Award this year goes to the University of Alabama.
Pretty nice. Does it get recycled? From year to year back to the thing? Or do they get individual?
I don't know, do they buy new trophies every year?
An award, or does it just?
Does it just like your name gets on it and then you put it back in the trophy? Do you get to take, we're wondering whether you take that home or do you
Is
have
that
to?
inscribed to you? Okay.
Uh-huh.